Legal dictation, exercise 80, start. All the three investigating officers have duly investigated the case and have recorded statement of various witnesses, including the accused persons, and disclosure made in the statement of all the witnesses and accused persons were duly verified and connected with the incident, which on the whole proves and establishes culpability and involvement of the accused persons in the incident. Full stop. Demand for ransom rupees 5 lakh has been specifically proved by the testimony of Shiv Shankar PW1 and Hira Devi PW2, and nothing more than was required to be proved for offense of demand for ransom. Full stop. To say that the demand of ransom was not proved, is not correct, and charge made under section 364A IPC is accordingly justified. Full stop. Right from the very beginning of the incident on 8/3/1999 and up to the filing of the charge sheet against the accused persons, all the material circumstances, facts and evidence, which was necessary to establish in order to prove guilt of the accused, have been consistently established. Full stop. Whatever contradictions appear in the testimony of the prosecution witnesses are natural and bound to occur looking to the facts and circumstances of the case, and these contradictions cannot be termed either substantial, one, or of the nature eroding the foundation of the prosecution case. Full stop. The case of the prosecution is proved beyond reasonable doubt against the appellant, and the trial court has taken just and consistent view of the evidence on record vis-a-vis factual as well as legal aspects of the case that formed basis of conviction. Full stop. Para. We have also considered the rival submissions and also considered the various assertions and denials made, pros and cons between the parties, and after considering the entire record, the moot point that arises for determinations of the appeal relates to fact whether the prosecution has been able to prove charges under various sections of Indian Penal Code beyond reasonable doubt against the appellants. Full stop. At the very onset, we may discuss certain admitted facts. Full stop. It is asserted on behalf of the prosecution that the incident of abduction of Adesh Tiwari took place on 8/3/1998, and it is alleged that the abduction was masterminded and facilitated by Fakkad gang. Full stop. It is admitted to the prosecution that no name of any member of Fakkar gang has been specifically mentioned in the first information report. Full stop. Bare perusal of contents of first information report itself reveal that the report was lodged on 1/10/1998, approximately after a lapse of 6 months and 3 weeks of the occurrence. Full stop. We may proceed with scrutiny of facts from this point. Full stop. It has come in the testimony of PW1 and PW2 that after Shiv Shankar, who was also abducted by Fakkar gang, was released in the month of May, 1998. Full stop. He returned to his village, then informed about the incident to Srimati Hira Devi. Full stop. He also informed Hira Devi about murder of Adesh Tiwari by the members of Fakkar gang, including the appellants, and a report in regard to these facts was given at the police station, but no action was taken by the police. Full stop. Para. Here we may observe that this factual aspect of prior reporting to the police has its inking the first information report itself, where it has been alleged that after the report was made, the concerned police station officer came to the village and advised informant Hira Devi to accede to the demand for payment of ransom. Full stop. However, the three investigating officers of this case, to be specific, first investigating officer Lallu Ram Tyagi, second investigating officer Chand Hussain, and third investigating officer Ram Nath Singh Yadav, PW8, PW7 and PW6, respectively, have denied fact of any such prior reporting at the police station, and they have flatly denied the claim of prior information of the incident being made to the police station. Full stop. At this stage, we may observe that some whisper and guess could have been exercised by us, if some worthy document or circumstances regarding loading of prior report were either produced for perusal of the trial court or were shown by circumstances of the case, but no worthy and authentic paper, record or circumstances has been brought forth by the prosecution by the informant. Full stop.